right, let's start here. Oops. You tell me I want to make it bigger or smaller? Okay, cool. So the members of the Ohio Real Estate Commission are appointed A, every 3 years, B, by the governor for a term of 5 years, C, by the director of the Department of Commerce, or D, every other year. Yeah, this one sounds familiar. I don't remember if it was on my test or not. All right, B. Yay, great job. So yes, so it is by the governor for a term of 5 years, which is wild. All right, next question. Oh, wow, there's only 5 questions in this section. A real estate sales agent is the subject of investigation by the Division of Real Estate. The superintendent's office sends a letter to the compliant and to the sales agent asking if they would like to meet to discuss the matter. This is called A, an informal mediation meeting, B, a formal hearing, C, appeal, D, arbitration. Oh yeah, and here I'll copy the question, put that in. Right, we got A. A is correct. Good job. So yeah, so this type of request is an informal mediation meeting. Cool. If a sales agent is found guilty of violating Ohio real estate advertising laws, the agent may be A, jailed for a term of no more than 30 days, B, subject to both fines, C, fined $2,500 per violation by the Ohio Real Estate Commission, or D, fined $200 per violation by the superintendent. This is regarding advertising laws. All right. Cool. So we have C. And so, wow, so it is B, both subject to both fines. Crazy. So both the Ohio Real Estate Commission and the superintendent have the authority to issue fines for the advertising violation. The superintendent may fine no more than $200 for an advertising law violation, while the commission may fine up to $2,500 for any law violation. Wow, I did not know that. Good to know. Okay, an agent is found guilty of a licensing law violation. The Ohio Real Estate Commission notes in its quarterly newsletter that the agent has had his license suspended and has been fined. This is known as A, real estate recovery, B, public reprimand, C, research and education reprisal, D, public embarrassment. All right, we got B. B is correct. Good job. Question there. All right, and next question. The superintendent's office conducts a hearing to determine whether there has been a violation of the Ohio Revised Code. The entity or person who holds a hearing to determine the punishment for a sales agent who has violated the revised code is the A, superintendent's hearing examiner, B, Ohio Real Estate Commission, C, superintendent, D, Court of Common Pleas. Well, these are tough questions. We got B, and B is correct. It would be the Ohio Real Estate Commission. All right, good job. Okay, cool. I got it right in here. All right. Cool, cool. Okay, next topic. Let's see. Do we not cover? So we just did state governments of the real estate profession. Then, right, we can pop into, if you guys want, leasing and property management. A property manager is instructed to show property to married couples without children. This is a violation of the marital status protected class under the Federal Fair Housing Act. B, this is not a violation of the Federal Fair Housing Act. C, this is a violation of the family protected class under the Federal Fair Housing Act. Or D, this is a violation of the Federal Fair Housing Act. So a property manager is instructed not to show a property to married couples without children. It was like kind of a poorly written question. Right. Oh, I was gonna say C too. So the correct answer is this is not a violation of the Federal Fair Housing Act. So the Federal Fair Housing Act prohibits discrimination based on family status, aka people with children. Marital status, however, is not a protected class, and so no discrimination has taken place. This question is set around understanding the seven protected classes. Again, marital status is not a protected class. Okay, well, this is kind of a poorly written question, but their eyes are talking about marital status, where sounds like it's a familial status question, but the best answer is like this is not violating the Federal Fair Housing Act. Yeah, that was tricky. A property manager is instructed not to show the property to any person over the age of 40. This is in violation of the A, none of the answers, B, Equal Housing Opportunity Act, C, Federal Fair Housing Act, or D, Civil Rights Act of 1866. So definitely knowing like what each one protects and which ones that and what statuses they don't protect would be definitely helpful for the exam. So property manager is instructed not to show the property to any person over the age of 40. This is in violation of what? Yeah, I was gonna say no. Huh. So it's saying none of the answers. A review of the Federal Fair Housing Act and Civil Rights Act of 1866 will show that neither prohibits discrimination based on age. Secondly, if there is a commercial property, the Fair Housing Act would not apply at all. Age is protected class under the ECOA, not fair housing. So the tricky part was they were saying that this is a commercial property, being that it's a property manager instructed. So if it was residential, then it would be under Equal Housing Opportunity Act. But since it's a commercial property, being that it's under property management, that it would not be any of the answers. Oh, that was tricky. Again, the wording is very tricky. An investor asks their neighbor to help manage the investor's 4-unit apartment complex. The investor agrees to pay them $100 for each lease for the neighbor executes. May the neighbor manage the investor's property? A, no, because the neighbor is a regular employee for the investor. B, yes, as the neighbor is exempt under the Mrs. Murphy rule. C, yes, but only if the neighbor complies with the Federal Fair Housing Act. D, no, because the neighbor needs a real estate license to manage this property. Oh, these are tricky. And yeah, and don't Feel like you can't participate. If you don't know it, guessing your best guess. I'm also guessing at a lot of these. All right, we got D. D is correct. Good job. So, no, because the neighbor needs a real estate license to manage the property. Good to know. All right, what type of lease would be used by a property manager in a heavy industrial manufacturing building? A, gross lease, B, percentage lease, C, land lease, D, net lease. Yeah, I remember having a few questions about the various leases. So definitely knowing each type and what is the best example associated with each type of lease. Wait, let's see. Yes, so C was a good guess. In a heavy industrial commercial setting, the tenant would pay not only rent, but also the landlord's property taxes, insurance on both the buildings and the personal contents, and all the utilities per a net lease. Okay, so the correct answer would be a net lease. Then a percentage lease is usually used in retail establishments where the rent is based upon the percentage of sales made. And a gross lease is usually found in an apartment where the tenant pays a gross amount of rent over monthly installments. Well, that was a tough one. All right, so it would be net lease for a heavy industrial manufacturing building. Right. Which of the following is a lawful activity of a property manager? A, running a credit check with the tenant's permission. B, inquiring about an applicant's religious beliefs. C, refusing to rent to an upwed parent with one child. D, investigating the applicant slash tenant's ancestry. Which is a lawful activity of a property manager. All right, we got two A's. A is correct. Good job. So it would be A, running a credit check with the tenant's permission. Going to be a lawful activity for the property manager. All right, good job. Those were kind of hard. Okay, let's go back to dashboard. We've been choosing very short sections with 5 questions. Let's see, let's stay up here. All right. Uh, let's see. All right, let's do property condition and disclosures. Okay. George, the owner of a single family home, has given his neighbor John the right to access John's property by using George's driveway, since John has no public road access to his property. The right is recorded in the public record. When selling his property, George will be required to disclose this fact because A, John has an easement opportunity and dominant tendency with regard to George's property. B, John has an estate at will with regard to use of the driveway. C, John has a deed restriction which affects George's ownership. Or D, John holds a defeasible fee estate in George's property. So there are similar questions to this on your test regarding the use of one's driveway. Okay, I was going to say A too. All right, we got A's. Great. A is the correct answer. So A, John has an easement, appurtenant, appurtenant, and has a dominant tendency with regard to George's property. Cool. All right. In evaluating the property to be insured and the buyer purchasing the property to determine insurability and premium to be charged, insurance companies often use which of the following? A home inspection done for the insurance company. B, a clue, which is a comprehensive loss underwriting exchange report. C, a coinsurance clause in the homeowner's policy. Or D, FICO credit scores of the buyer and seller. I think I may, oh no, made something similar on like this sometimes. It's crazy because I feel like I don't remember reading this in the books, but okay, so some to A. So a tricky part, the correct answer is B, which I don't remember reading about in the book, but which is that comprehensive loss underwriting exchange report. So insurance companies access a database of prior claims involving both the purchaser and the property. The clue report enables them to evaluate insurability and establish premiums. So when you see a question about a property regarding insurability and the premium to be charged, just remember the clue. Comprehensive loss underwriting exchange. Okay. A property owner is involved in litigation which could result in judgment affecting title to their property. Because of the time delay between filing a lawsuit and rendering of a final judgment, what action could be taken to protect a claimant's interest? Is that A, have the property owner execute a waiver of liens? B, have the clerk of courts enter a confession of judgment? C, secure a writ of execution, or D, record a notice of lis pendens. Okay, so what was it, A? Yeah. Oh no. All right, yeah, let's try A. I was thinking between A and C. Okay, so it is D. Oh, I was not gonna think D. So it would be record a notice of lis pendens. Let's do that. When a suit is filed that affects title to real estate, a special note known as lis pendens, litigation pending. Oh my gosh, I did not remember that's what it meant. So lis pendens means litigation pending is recorded to protect the claimant's interest. A writ of execution is issued after a judgment is awarded. And then a waiver of liens is used to protect against a mechanic's lien. And then a confession of judgment is used to avoid the necessity of court action to enter judgment. It is executed by a debtor. Oh, I like that in the question rationale, they explain everything and explain all of the answers listed in better detail and why D would have been the best answer. So it would be a record a notice of lis pendens. All right. When an owner of property fenced their yard, they locate the fence where they believe the property boundaries were located. What action should a prospective buyer take in order to ensure the fence does not encroach on a neighbor's property? is that A, rely on disclosures made in a seller's property condition disclosure statement. B, have a boundary survey done by a licensed registered land surveyor. C, have a title search done to public records and an abstract of title prepared. Or D, personally contact all owners of the property adjacent to the property being purchased. All right. So to ensure it would not encroach. Yeah, so C would be a good guess because it should tell a lot about the property in there. B is going to be very specific on which or the boundaries of the property itself, and we'll have legit records in county records on where the property lines are. So it would be B. B, so a licensed surveyor is trained and authorized to locate property boundaries and identify possible encroachment. All right, good job. Which of the following would a broker representing a seller require to disclose to an unrepresented buyer? Is that A, the fact that a previous owner or occupant died of AIDS or was HIV positive? B, the lowest price the seller has indicated that they will consider? C, the type of listing contract that exists between the seller and broker? Or D, a latent defect known to the seller and broker regarding condition of the property? So the following, a broker representing a seller requires close to an unrepresented buyer. All right, we say C. This is a good guess. Let's say C or D. Okay, so C would definitely need to be discussed between seller and broker. Along down the line, it would be discussed with the unrepresented buyer, but the definite one that needs to be disclosed is going to be the latent defect known to the seller and broker regarding the condition of the property. So latent defects are hidden and not discoverable by an ordinary inspection. Definitely good to know that latent defects are hidden and not discoverable by an ordinary inspection. And then sellers and brokers must disclose latent defects. Yeah, so definitely knowing the difference between latent defect and patent defect. Also never know if I'm saying half of these words right. Okay, next question. Home warranty programs, which typically cover such things as plumbing, electrical, heating, and air conditioning systems and appliances, are A, always provided and paid for by the seller when property is listed in a multiple listing service. B, optional programs purchased by buyers or sellers that include specified coverages, deductibles, limitations, and exclusions. C, only recommended if a seller does not provide a property condition disclosure statement. Or D, required if a buyer is securing a federally related mortgage loan. So you get to learn more about these when you are an agent. So we got D. So on this, the best answer is going to be B. So it's an optional program. So either a buyer or seller can choose to purchase a home warranty for the property, whether they're the seller and they're like, to entice buyers, they're like, okay, we'll throw in and cover a year of home warranty. And then sometimes buyers are like, sellers aren't covering it, I'll buy a year of home warranty for the various appliances or heating, air conditioning systems that are in there. So if they're older, if the appliances in there are older, getting a home warranty will definitely help in the long run. So in many situations, buyers or sellers choose to purchase a home warranty program to cover potential problems with mechanical systems and appliances. So instead of worrying about them breaking, you can always get a home warranty to kind of cover that if you do have any issues within when that home warranty is within the dates that home warranty is in fact affected in effect. I should say. All right. Next question. In order to ensure that a prospective buyer is provided with information concerning structural, mechanical, and other property conditions so that they can make informed decisions, licensees representing sellers should A, have the seller complete a property condition disclosure form to accurately and honestly disclose what they know about the property. B, complete a property condition disclosure form on behalf of the seller and provide to prospective buyers. C, require that only buyers represented by buyer's agents be shown the property. Or D, insist that the seller have the property inspected by a qualified professionals before listing it for sale. So, which is the best answer here? He did give some good options in here, so it is tricky to rule them out. But most common one. All right, we have, I was gonna say ARD, so A, we got two A's, cool. A is correct, good job. So it would be A, have the seller complete a property disclosure form to accurately and honestly disclose what they know about the property. Especially since that the seller has been living in the house for X amount of years, they know the most about the property itself. So that's where the property disclosure comes into play. You need to have them fill those out before you're even able to list the property. All right. Which of the following could be made available to a buyer to indicate that a property owner had authorization to make any alterations or additions to the property and that work has been done to applicable standards? Is that A, receipts and work orders from a contractors who performed the work? B, plans and specifications prepared by a registered architect? C, a home inspection report prepared by a professional home inspector? Or D, a building permit and certificate of occupancy issued by the municipal government? Uh, Seems so tricky. All right. And that is correct. Good job. I know D did sound confusing, but that is the best answer. So before anybody, always recommend before, if you own your home or if you are helping your clients with maybe they want to add an addition or add an extra garage or something like that, definitely going and getting permission from the city or municipalities. They have various restrictions, and so you may need to pull a building permit or pull some type of certificate to then be able to do those improvements on the home. So yeah, so a building permit and certificate of occupancy is issued by the municipal government saying, yep, this was approved by us for them to add this additional, whatever it may be, to the property. All right. The term red flags used in reference to property condition refers to A, visual signs or indications of a defect in a structure, its major components of the property itself. A latent defect not discoverable by the ordinary person. B, any mechanical component in a property at or near the end of its economic life. Or D, any off-site issue that may have a negative impact on the property's value. So the term red flags used in reference to property condition refers to what? Yep, correct. Or A is the best answer. So that would be a visual signs or indications defect in structure. It's a major component of the property itself. Yeah, definitely anything regarding structural damage is red flags. A property considered undesirable because of an event that has occurred there, such as a suicide, murder, illegal drug manufacturing, or gang related activity, is classified as A, nuisance property, B, stigmatized property, C, unsellable property, or B, uninsurable property. Uh, we're going to say B. B is correct. Stigmatized properties are those the public deems undesirable because of the events that have occurred there. All right, good job, guys. Great participation. Okay, let's go to our next topic. I know a few other people popped in on the study session. So if there's a certain topic you want to focus on, go over the questions and take a little quiz on that, feel free to put it in the chat and we can definitely go over that topic. Transfer of title, sounds good. Okay, let's start the first session. Cool. A buyer asks for a chronological summary of the liens, encumbrances, chain of title, transfers, and deeds that have been recorded for the property they are about to purchase. Which would fulfill the buyer's request? A, an abstract of title, B, title insurance, C, general warranty deed, or D, a title search. Right. Cool. We got abstract of title. And that is correct. It would be abstract of title. So to have all of those things is going to be abstract of title. Good job. Anytime I saw like chronicle summary of liens, I did like abstract of title. Oh wow. An abstract of title is a what? A written declaration by a person executing an instrument signed before an officer authorized to give a note. A chronological summary of the essential provisions of every recorded document pertaining to a particular parcel of land. A C, sworn statement to the title is good. Or D, contract whereby a title insurance company identifies the owner against loss due to defects and hidden risk on the title. All right. I didn't give it away before. It'd be B. Whenever I think of abstract title, I think of chronological summary of the essential. Yes, so B is correct. Listener, good job. Real estate Real estate taxes are prorated as the day of closing. The real estate taxes are A, debit to the seller and credit to the buyer. B, debit to both the buyer and seller. C, credit to both buyer and seller. D, debit to the buyer and credit to the seller. Ooh, this is a good one to know for the test and for real estate. A lot of the information on the test is just to know it for the test, and then you can always Google it or look it up later when you have your license, but definitely this is going to be good to know all around. This is kind of tricky. I got two D's and a C. All right, so it's actually going to be A. So debit to the seller and credit to the buyer. So since the seller owned the property, like let's just say the first half of the year, and then the second half, the buyer is going to be in charge of those. The debit of the seller, they are going to pay for the first half of the year taxes, and that's going to be credit to the buyer. So real estate taxes are debit to the seller, who must bring the taxes current up to and including the day of closing. They are credited to the buyer when the taxes are prorated between the two parties. So then the buyer, when they go to file their taxes, they're going to use the credit they receive from the seller for that first half of the year to pay for their taxes, property tax. All right. An affidavit of title is A, sworn statement that title is good. B, disclosure of the property's known physical defects. C, disclosure of the relationship in which one property acts for or represents another. Or D, pledge of real property as security for repayment of debt. Got A. A is correct. So affidavit of title is a sworn statement that title is good. All right, good job. Next question. A mortgage company typically requires title insurance to cover the A, seller, B, mortgagee, C, mortgager, D, mortgagee and mortgager. So a mortgage company typically requires title insurance to cover who? Not sure. Where would say B, mortgagee? Correct. Yep. So the mortgage company, which is the mortgagee, requires insurance only protect itself. It may be advisable or even customary for insurance to be purchased for the borrower, which is the mortgager, but is usually not required. All right, good job. So definitely knowing that the mortgage company is the mortgagee and the borrower is the mortgager is super important. So mortgage company equals mortgagee, borrower equals mortgager. That will be very helpful in the test. All right. Oh, we're just flying through topics. Okay, so I think we probably have time for one more. So various topics, there are the various categories. All right, contracts. Sounds good. Oops, I clicked wrong one. Okay, perfect. Okay. Adam and Jenny enter into an agreement wherein Adam will buy Jenny's house at the asking price if Jenny will install a new roof, and if Adam can qualify for a loan sufficient to cover the purchase. Until the roof is installed and the financing obtained, the contract is said to be A, rescinded, B, executed, C, executory, or D, voidable. All right. C is correct. Good job. An executory contract is one which the parties have agreed to the terms, but conditions still remain to be fulfilled by the parties. Once all conditions are met and all that remains is closing, the contract is said to be complete or executed. Voidable contract is one that may be rescinded, and the contract has been rescinded is void. Cool. Correct. So executory is right. Perfect. Walton decides to sell his cabin on the lake and offers it in a letter to his regular postman, Bill, at a price of $5,000. The next day, Walton receives a note from the neighbor, a close friend of the postman, who says, "I accept your offer." Is Walton obligated to sell to his neighbor? A, no, because only the offeree can accept an offer. B, yes, because the acceptance was within 3 days. C, no, because no licensed agent was involved. D, yes, because both the offer and the acceptance were in writing. Not tricky. All right, we have D. Okay, so it would be A. No, because only the offeree can accept an offer. No one but the offeree can accept an offer. The acceptance by the neighbor is not valid no matter how or when it was communicated. It is in fact a new offer, which Walton now may or may not accept as he chooses. So Walton he's not obligated to sell the seller, or sell to the neighbor, but Walton needs to also agree to it. But since he was offered to the postman and not the neighbor, it becomes a new offer. And Walton is then has to decide whether he wants to sell it to the neighbor now. Interesting question. A lender qualifies a new borrower who signs a note and mortgage. Then the same terms of the note and mortgage are transferred to a new mortgager, relieving the original mortgager of liability. This is known as A, assignment, B, subrogation, C, defeasance, D, novation. So transferring one mortgage to a different person, relieving the original mortgager of liability. What is this called? We got novation. Novation is correct. Good job. I could not remember them in. So the substitution of a new contract with withdrawing party relieved of liability is called novation. Assignment is a transfer for one party's interest in an existing contract to somebody else. And then assigner is relieve liability. Subrogation is the substitution of one creditor for another with the second creditor having the same legal claims and rights. And a defensive clause declares that a mortgagor is satisfied and the final payment is made. So definitely great knowing all of these terms for the test. Vocab is a huge role. Okay, an option. A requires optioner to complete the purchase if the optionee so selects. B makes the seller liable for commission. C keeps the offer open for a specified time. D gives the optionee an easement on the property. Oh, I thought it was C too. So, okay. So the best answer would be A requires the optioner to complete the purchase if the optionee so elects. A seller is committed to a commission through listing the right to use a property for a particular purpose is an easement and offers a proposal while an option is a contract. Okay, so if the optionee elects the optioner is to complete the purchase, so it requires the optioner to complete the purchase if the optionee elects. Does that make sense? All right, Mary buys Sally's property, which is subject to a mortgage. After 5 years of payment, Mary defaults and misses a payment. Which is the appropriate remedy for the original mortgager? A, sue only Sally, as Mary took only the property subject to a mortgage and there was no assumption. B, the mortgager has no recourse since there was no assumption. C, sue Mary and Sally as they both was they both liable on the mortgage, or D, Sue only Mary as she assumed Sally's mortgage? Oh, what a question. Yeah, this is hard because we don't know if she assumed it, but pretty much sounds like it. All right. All right. So in this question, Sally is the mortgager. Most people confuse mortgager and mortgagee. In this case, the mortgagee is the bank. The question plainly states that Mary bought Sally's property, which was subject to a mortgage. It does not state that there was loan assumption. I knew they were going to say this. So since they didn't specify in the question, even though they said that they bought the property, we just assumed that they assumed the mortgage. But since they didn't say that in the question, we can't assume that they assumed the mortgage. So the mortgager has no recourse since there was no assumption. That was tricky. In a face-to-face meeting, a farmer offers to pay a roofer $1,500 to install a roof on their barn. The roofer says, "I'll do it tomorrow." Which type of contract do they have? A, option, B, express, C, unilateral, D, voidable. So I put the questions in the chat as well as the question rationale. If you type these in to Google, like any of the questions or even sometimes the question rationale, it'll sometimes pull up Quizlets, and then that's a great way to study is using the Quizlets because you'll have CompuCram questions on Quizlet. So yeah, definitely copying and pasting the question into Google and then, or even on Quizlet, and seeing what that is. All right. Option express. And that is correct. It is B, express. Okay, next question. A seller signs an exclusive agency agreement with a broker. The day after the listing is signed, the seller's brother-in-law decides to make an offer on the property without knowing that the property has been listed, which is true. A, since a buyer was found during the listing period, the broker will be entitled to a commission. B, the broker is not entitled to a commission. C, the seller will have to pay the commission to the broker. D, the buyer will have to pay a commission. Correct. B, the broker is not entitled to a commission. A seller signs an exclusive right to sell agreement with a broker. However, the seller's brother-in-law makes an offer on the property the next day, not realizing that it's been placed, which statement is true. Hi, Bobby. A, the seller will not have to pay a commission. B, since the seller found the buyer, the listing is void. C, the broker is not entitled to a commission. Or D, the broker is entitled to a commission. You're panting in the background. Puppy just got back from a walk. Okay. And correct, good job. It would be D. The broker is entitled to a commission. All right. Melissa went to the dry cleaner and dropped off her good wool coat to be cleaned. When the clerk accepted the coat, Melissa and the dry cleaning operations had just entered into which type of contract? A unilateral contract, B, implied contract, C, executed, or D, complete? Nothing. A. I was thinking A or B. So an implied contract is an agreement that has been put into words but as terms apply the actions of the parties. Unilateral is Good guess though, for sure. I was if you wish it was gonna be that or implied. So implied, it's like already implied that you're bringing it to the dry cleaning. A contract is entered into on fraudulent terms introduced by the seller. Upon discovery of the fraud by the buyer, the contract would be A, voidable by the seller, B, void, C, voidable by the buyer, or D, valid. It's hot out there. All right, we got B, void. We're gonna say that too. So it would be C, voidable by the buyer. These are always tricky questions when they use void and voidable. So in cases of fraud against a buyer of real estate, the buyer may affirm or disaffirm the contract within a reasonable time after the truth is discovered. The contract would be voidable by the buyer until he disaffirmed it. At that point, the contract could be void. All right. Good jobs. Next question. Seller Joe's agent personally delivered Mary's offer to buy his house. Joe said he would like to think about it for a couple days. Later that week, without making a single change to the contract, Joe decided to accept Mary's offer and signed it. Then he addressed it to Mary, went back to the post office and mailed it. Is this contract binding to on both parties? A, no, because Mary had received it from the agent. B, yes, because all that was required was Joe's signature. C, yes, because Joe sent it to Mary in the mail, or D, no, because Joe didn't give it back to his agent. Wait. Oh. Would be okay. What should be? I can't remember if this will be no. Might be. Wow. So yes, because Joe sent it to Mary in the mail. Huh. The mailbox rule says that when an acceptance isn't communicated directly, either in person or over the telephone, it is effective as soon as it's placed in the U.S. mail to the offerer, even though the offerer has not received it yet. The mailbox rule applies only to acceptance, not to revocations. Revocations are not effective until they are actually received by the offeree. Oh, that was a tricky one. I did not know that. How interesting. So if he made any changes to the contract, that would not obviously be binding by any means. She would have that then creates a whole new contract. But since he didn't make any changes and he sent it back, it is good to go. All right, an option agreement is a both a bilateral contract and a unilateral contract. B, neither a bilateral contract nor a unilateral contract. C, unilateral contract, or D, bilateral contract. Oh, this one's tricky too. Hmm. There are other dogs. All right, so it would be C, a unilateral contract. An option is fully negotiated unilateral contract in which the optioner offeree irrevocably agrees to hold the offer open for a certain time in return of the optionee or offeree's payment of the option money. Well, stop. So an option agreement is unilateral. So remembering that an option agreement is a unilateral contract. Who is authorized to rescind a voidable contract? Is that A, either party, B, the agent and seller only, C, only the minor, D, neither party, only a void contract may be rescinded. Gosh, when they use so many vocab words in a question, it's hard to rescind and voidable contract. And then remembering what each of them mean. It's tough. Definitely going with your gut feeling. Yeah, they're gonna say A as well. All right, so C, only the minor. Only a voidable contract may be rescinded and only by the injured party. A minor is not held accountable in a real estate contract and therefore may rescind the contract due to lack of contractual capacity. Crazy. So the one that I didn't think was so only a minor is authorized to rescind a voidable contract. I remember this was a question on the exam, so definitely got that wrong. But so who is authorized to rescind a voidable contract? Only the minor. All right. A seller signs a listing agreement that commences today and ends on December 31st of this year. The listing agent tries as hard as possible, but simply cannot find a buyer who is interested in the property. After the first year, the listing is terminated by A, expiration, B, seller rescission, D or C, statute of fraud, D, unilateral agreement. So in this case, it's going to be expiration. So the listing agreement expired, basically. You can always try to extend the listing contract, and the new listing agreement would have to take place. But in this case, it expired on December 31st. So come the first of the year, the listing is terminated. All right. John and Mary are getting a divorce. John tells Mary that unless she agrees to sell their home immediately and split the proceeds, he will institute legal proceedings to gain custody of the children. If she agrees, the sales contract may then be voidable because of A, consideration, B, duress, C, offer and acceptance, D, legality of object. Bruh. All right, so it would be duress is a useful defense against enforcing a contract because there is no genuine meeting of the mind. So almost like you're like forcing them to make a decision. A contract entered into under duress is not enforceable because it's again enforceable against the forced party. Consideration, offer, acceptance, and legality object are all essential elements of a contract. All right, good job, guys. Well, thanks so much for participating.